Hello, everyone, and thank you for joining us today. I'm Seth Bloom here at Levelset. I'm the Senior Director of Attorney Services and do a lot of work with the Expert Center here. I'm really excited today to have an excellent lawyer from the Houston, Texas area, and he is Ben House from House, Perron and House, and he primarily does construction law, although his firm does do some civil litigation in general, but he is a construction law guy. So without further ado, I want to turn it over to Ben. He's got a great presentation for us today, and we're excited to have him.
Thank you, Seth. Hi, everybody. My name is Ben House. Like Seth said, my firm is House, Perron and House. I practice on the west side of Houston, also known as Katy area. Although Houston got so big that it actually ate Katy, so we're surrounded again. So I wanted to, based on what's occurring in the country right now with COVID, there is so much confusion, consternation, worry about how the constructors' contracts are affected, how your duties are affected, and that goes one of two ways. And before I get into that, I'll tell you a little bit about myself. I'm a partner at my firm. I handle all of the construction litigation at the firm. I am a litigator. We go to trial, at least we used to before COVID shut our jury trials down. It's not looking like we're going to have a jury trial for a little bit here because the courts and government understandably want to be very safe. But I'm a construction lawyer. I'm a Texas Aggie. I have a construction science degree from Texas A&M, so I'm construction all the way back from the beginning. So the purpose, why are we here? All right, I'm not going to educate you on the law. I'm not going to talk to you about legal cases. I'm not going to cite Supreme Court precedent to you. I'm going to tell you what you need to know. I'm going to tell you generally, rule of thumb, how things work. As specific as I'm going to get is talking to you maybe about specific terms in some AIA contracts and some consensus docs contracts and some federal contracts. So if you're one of those contractors who uses one of those documents, stay tuned. The other thing I'm going to talk about is, and I think this topic is not discussed as often as it should be, what if your contract isn't that sophisticated? A lot of my clients are subcontractors. They don't have the big, high-dollar, sophisticated contract that often happens between owner and general contractor. Multi-million-dollar contracts that I'm asked to consult on and litigate on are routinely very, very simple, sometimes poorly drafted, sometimes creatively drafted. But I want to talk a little bit about what the law has to say in that situation. So, now we're done with that, let's get started. And I'm going to throw this presentation up to assist folks. Okay. How to unlock payment when construction is blocked. And that you're going to figure out that means something a little different. All right. There's me. Hi. Major takeaways. COVID-19 is not an automatic excuse to get out of a contract. I wrote that because it's not an automatic excuse to get out of a contract. Contracts may very well continue, especially in areas where construction contracting is not subject to stay-at-home orders, which is most areas in Texas that I have seen. So if if no law says you cannot build no matter what, then you have to then think about, okay, what does the law say about epidemic circumstances? And what does my contract have to say about this? It's pretty straightforward, but let's figure that out. Then I'm going to talk about force majeure language. To get the benefit of that language, you're going to figure out you have to have it. And a lot of people seem to think when they have a force majeure clause, boy, they're covered and they're in great shape. I got a force majeure clause. You won't even believe I'm totally off the hook, or I can have as much time as I want. Nope. We'll talk about that. Last thing I want to talk about is dangerous phone calls. What you say can be used against you. That's kind of a lawyer joke, but in reality, You do have to be very careful about what you say you can and cannot accomplish and will not do under COVID circumstances, because it can actually have it can cause you to breach your contract without you even knowing it. Let's talk about that a little bit. All right. Excuses go two ways. Ben, what's your point? A builder needs to know which hold water and which don't. So all I'm getting at here is that as a contractor, if you're a subcontractor, you have folks that might be trying to get out of their contracts under you, or telling you they can't perform their contracts under you or need more time. And then you yourself might be telling, either because of your subcontractor or because of things going on in your own operation, hey, general contractor, I need more time, or I'm not going to be able to do this at all. So both of those can happen under the very unpredictable COVID circumstances. You never know which companies are up and running and which aren't. So that's my general, that's how we're going to approach this today. All right. Normal rule, no excuses. Common law rule is normally a party who contracts to do something that was possible to perform when the contract was made will be held to that performance, even though it subsequently becomes more difficult or impossible to perform. The regular rule, ladies and gentlemen, is that if it could have been done when you started the contract, the party who contracted to do the work bears the risk of not being able to do the work. It's a harsh rule. It's a scary rule. It doesn't seem very reasonable, but it is actually the law. So if that's the law, how do you protect yourself? How do you get around it? How do you make sure, how do you either hold people to this or protect yourself from it? All right. The impossibility defense. This is not language that's going to be in contracts. This is the law. This is actually the common law. And these are common law defenses. What does common law mean? Common law means that this is baked into the law. This is built in. Unlike a force majeure clause or a no damage for delay clause or a paid if paid, paid when paid clause, these are in the law. So these don't need to be written anywhere. Okay, and there's three general names for this impossibility defense. Those are right there in front of you: impossibility of performance, commercial impracticability, that's different from impossibility, and frustration of purpose. By the occurrence of an event, the non-occurrence of which was a basic assumption on which the contract was made. So the whole reason we got into this contract has been destroyed. Now, if you're building a commercial structure, and let me get back to where I can see somebody here. If you're building a commercial structure, the purpose of building that structure, to have a bank, to have a store, whatever that purpose is, may or may not have been destroyed based on what you're actually trying to build. So you see, that's just because COVID exists doesn't mean that the entire purpose of building the thing you meant to build in the first place doesn't exist anymore. In fact, I would argue that usually it does. So this, while it may be possible to utilize this under circumstances where the owner for the owner, basically, where he says, look, there's no point in doing this anymore, I'm going to cut you out. The general contractor and therefore the subcontractors might be in a position of saying, oh no, this is not good. Except, let's go back to the screen here. It's this common law idea of impossibility of performance is generally only applied under three specific circumstances historically in Texas. We're talking Texas law here. That is, impossibility of performance generally applied under these three circumstances: the death or incapacity of a person who is necessary for performance. Okay, in the construction context, throw that out the window. Almost everyone involved in construction is fungible. When you're talking about someone necessary for the performance, you're talking artists, musicians, people that have a skill that is not inherently fungible. You're hiring that person for that skill. Very rarely, if ever, applied in construction. Number two, the destruction or deterioration of a thing that is necessary for performance. Okay, now we're getting somewhere. Destruction or deterioration of something that is necessary performance. Well, that's typically, this is utilized in construction. Its applicability to COVID, I think, is not great. And here's why. In construction, if something happens to what you're building and it's not your fault, if you know, even if a fire strikes the property, or you're working in a materialman's situation or an auto mechanic's situation, the car is destroyed. Okay, the subject of what you're working at, for no reason, well, not caused by you, is destroyed, that can release you from your contract. Now, we're in the COVID situation, we're mostly seeing, it's dangerous to get folks to work. It's dangerous to run offices, but the actual premises, the tools, the items, the things you need to build are not destroyed. So, and these three items are read in a very limited manner, such that number two's application is under COVID. Creatively, maybe, but I'm not expecting to see that a lot in coming COVID litigation, which is coming. Number three, the big one, the important one, prevention by governmental regulation. Okay, this comes from a 1992 Texas Supreme Court case. I said I wasn't going to do any of that, and I'm not. But prevention by governmental regulation is read stricter than you might think. So in that case, the idea was a new law, which we'll talk about a little bit later, a new law came into effect and basically made the premise of the contract they agreed to impossible. Like you're building a coal-fired power plant, and this is not the facts of that case. And they pass a law saying you can't build coal-fired power plants. Okay, well then under Texas law, all right, we're obviously talking about a situation that can release a contract. All right, let's scoot over a second and talk about COVID. COVID-19 comes up. As a result of COVID, we have seen a bunch of orders. The Texas Supreme Court has issued orders. The individual counties have issued orders. Yesterday, Judge Lena Hidalgo issued an order that everyone has to wear masks in Harris County. These are major orders, stay-at-home orders being huge and then you have essential businesses mixed with stay-at-home. You have the danger of operating those businesses. So prevention by governmental regulation. You see the obvious issue here. Does the regulation, if construction is in your area an essential practice, has the government regulation actually stopped us effectively from operating, even though it says we're essential? So you're an owner of a construction company or a subcontractor. You don't want to endanger your folks. Nobody does. They're employees, but you're an essential practice. You are authorized by the government of the state of Texas to do your work. You're necessary. You're essential. All right. Well, does the government, does regulation, these stay-at-home orders of the government actually really, in reality, prevent you from doing your work? And I think the argument there, there's no case on point on this. There are no cases on point on COVID yet. But I think the argument is very strong there that yes, prevention by governmental regulation, especially in a post-COVID light where you're dealing with juries and judges that all lived through COVID themselves, and the law is on the books saying, hey, this contract was made impossible effectively by governmental regulation. I think you're going to see a warm reception to that. I really do. This is just my one lawyer's opinion, but I think that's coming.
Ben.
Yes, sir.
I just wanted to inject something. Having practiced law in New Orleans for many, many years, this reminds me of after Katrina.
Yes.
And I know the Katrina excuse for not showing up to court or missing deadlines
Right.
had lasted for years, but I think it's only effective within the courtroom for about 6 months. So
Right.
I just wanted to give that perspective that sometimes after these crises, people do try to take advantage of them.
They do.
Yeah.
I'm seeing lots of reports of lots of really major companies getting a lot of government money. Good for them, I guess.
Mm-hmm.
It's neither here nor there for us, but this brings up a critical point that I should have put in this deck, but I didn't. And that's this. I'm getting this question a lot in my daily practice. While the courts are not, the courts are technically open. We're not having jury trials. We are having hearings. I'm having Zoom hearings all the time. I'm having Zoom depositions. For the very first time, I was in a hearing this morning. The judge told us he had his first Zoom bench trial. A bench trial is when there's no jury. So they tried evidence. They put a case on in front of the judge on Zoom in Harris County, Texas. Okay, I think we're going to see a lot more of that. So the question I get a lot from contractors is, hey, COVID's happening, delays are happening. My general contractor says, hey, you're okay, the delay's all right. Owner's saying delay's okay. But in the meantime, here's the deal, payment isn't occurring. Texas law has extremely strict lien rights. Part of the existence of companies like Levelset and Levelset itself is to help you protect those lien rights, okay? That lien law has not stopped because of COVID. It has not been frozen because of COVID. If those lien deadlines, which are drop dead critical in Texas to protect your lien rights as a subcontractor. General contractor, you can kind of get away with murder. Subcontractors, subcontractors, second tier contractors. Your lien right, ignore anything any general contractor says, ignore anything any owner says about getting your liens on file and getting your notice letters out. The requirements of Texas law have not changed. It is just as critical that you are just as timely about those letters. Now, I would recommend, greasing the skids there a little bit with those folks. Say, look, hey, owner, general contractor, I got to send these things. I have to, I don't have a choice to protect our rights. I hope you understand, I just have to do this. I do absolutely recommend doing that because nobody likes to get a lien letter in the middle of COVID, and that can really harm construction situations. But if you handle it right, it's okay. And let me tell you, if you feel like if you're a subcontractor who feels like no other subcontractors are exercising their lien rights, you'd be incorrect. So you need to be, the squeaky wheel gets the oil. You need to be on top of your rights, as always, but especially now when a lot of people are being lulled into a false sense of everything's going to be okay kind of situation. Okay, let's go back to force majeure. All right, I have put a sample force majeure paragraph here. You can take the time to read it. I'm not going to read it to you because it doesn't really matter. Why does it really not matter? Because yours isn't going to read like this. Force majeure clauses are not the same across the board. Force majeure clauses are actually almost always different from one another. So what I want to talk about instead is how they work and what they do. Okay, first things first. You have to actually have a force majeure clause. Okay, they're not ubiquitous. They're not always in contracts. Sometimes they are, sometimes they're not. But if you don't have one, and here's the critical part. They're not always called force majeure. Force majeure means, it's a French phrase meaning basically stronger than. And so force majeure means that's your act of God clause is usually in your force majeure paragraphs, as are a number of other kind of excuses listed there. So if you have one, this is how you're going to analyze it. Okay, a category of your clause has to apply to COVID-19. So how these force majeure clauses usually work is there are a list of categories. And it's very typically, if I can go back here for a minute. Okay, strikes, fire, flood by the occurrence of any other event beyond the control of the parties hereto. That's called the catch-all part, is the occurrence part. Strikes, fire, flood, or the occurrence of any other event beyond the control of the parties hereto. Now, this would be a really handy version of this clause to have in your contract for COVID. It would seem like. I'm going to jump ahead here and skip at the bottom of this page. You'll see the rule of adjustum generis. You don't need to remember that. What you need to know is this. Sometimes there's catch-all language. Sometimes there's catch-all language that seems like, you know, fire, flood, military intervention, or anything just like that clause we just read, or anything else that might be out of your control. Okay, well, there's this doctrine of adjustum generis, which means if the thing that is happening is not somewhat related to, somewhat similar to the other things that are actually listed, the catch-all phrase will not catch it. So while the language, if you just read your contract, you think, if I just read my contract, I understand what it says. Well, here's where the law says, no, you don't, because we thought we were special. So the law comes out and says that if it's not similar, and this is the law in Texas, if it's not similar to one of those things listed, then you may be out of luck. So just watch out for that. It's better to have language that is directly on the nose when you're talking about this stuff. All right, so let's go back here. All right. So going back for just a second. We talked about the category, the second dot there. Okay, was COVID-19 foreseeable? So there's some debate. I've read a lot of blogs saying that, well, pandemics are actually technically foreseeable. And if they're foreseeable, then there's some law that force majeure clauses won't work, because they really are supposed to be unforeseeable. Very similar to, in my opinion, I think this argument is not very strong. Long story short, I think that very few force majeure clauses are going to be thrown out or not utilized by courts because the COVID-19 epidemic was foreseeable. I don't see it for a lot of kind of nitty-gritty legal reasons. It's my personal opinion that's not a very good defense to a force majeure clause. Okay. If notice is required, it had better been given. This is rule number 1 in Texas construction. If you have notice requirements in your contract, you better meet them. And almost all force majeure paragraphs or terms require you to provide notice. We're going to talk I'm going to hit AIA and consensus docs contracts very briefly here in a minute, but long story short, what force majeure language usually does for you, it doesn't release your duties under the contract. It gives you more time. If you're a subcontractor, if you have a sub that is claiming force majeure, it doesn't usually release them from having to work with you. It just gives them more time. So that's kind of how you analyze that. If somebody comes at you with one of these things, is okay, well, you might have one, but you don't just get to collect a paycheck and run off the project. That's not how this works, unless you actually have a consensus doc contract, in which case it might be how it works. We'll talk about that here shortly. Finally, if it does apply, it may excuse the non-performing party from completing their work entirely or only partially. Yeah, that's what I just talked about. Unless you have a consensus doc contract, termination, and under certain circumstances under the AIA contract, the regular law or a regular force majeure clause, absent being drafted in one of those two contracts, usually doesn't release you from the project entirely. Okay, backing up for a minute, in force majeure in force majeure paragraphs, there's usually language called act of God or other act of God. It's it's most frequently used as a catch-all. And this definition I gave here is actually the Texas definition of an act of God. It's an occurrence is caused by an act of God if it is caused directly and exclusively by the violence, exclusively, that's an important word, by the violence of nature without human intervention or cause, and could not have been prevented by reasonable foresight or care. If you find yourself thinking that's a pretty high standard, you're right. So this kind of goes along with the use of catch-all language in force majeure clauses. If your force majeure clause doesn't say epidemic or disease or something kind of in that vicinity, it may not be the overbearing legal defense you think it is, and it may not be the strong overbearing legal defense that a subcontractor of yours thinks it is. And so it's important to know these rules of thumb to understand that these things are not bulletproof if they're yours or they're somebody else's. So there's some negotiation to be had here. Okay. The last thing I say is catch-all phrases actually catch less than you would expect. That's what I've been discussing up to this point. Okay, now before I get to the repudiation and anticipatory breach, or this big fancy word for saying, watch out for what you say. It can really backfire on you. I did want to discuss briefly for the folks who have AIA contracts or consensus docs or federal construction contracts, you'll want to pay particular attention here. AIA 201, which is the general contractor's contract. The AIA also makes subcontractor contracts. Also, consensus docs does too. Under section 8.3.1, that's where you look if you have an AIA contract. Hot tip. Unusual delay in deliveries, unavoidable casualties, or other causes beyond the contractor's control, or by other causes that the contractor asserts and the architect determines justify delay, that allows you to have a delay. So what is this? It's a force majeure language. It's not called force majeure in the AIA or the consensus docs agreements. It's called, it's delays and extensions of time in the AIA, and it's a national emergency or governmental act in consensus docs. In the federal contracting, it's called academics and quarantine restrictions, because son of a gun, the feds thought ahead on this one, although their contracts are, usually you're looking at something considerable if you're working for the federal government. If you're a federal contractor, you know exactly what I'm talking about. Even my eyes go crossed reading those. So both the AIA and consensus docs have something special in them, and that is the potential to terminate a contract. If under consensus docs, a national emergency or other governmental act can be used as a basis for termination of the contract. The owner may also terminate, as is if you would like to, but there's typically you get paid for the work you've done at that point, plus a premium that's usually tagged on in the end on the consensus docs. I have negotiated heartily for those premiums before to good effect for my subcontractors and general contractor. So AIA consensus docs, long story short, you have a force majeure clause. What do you have to do? You have to exercise your notice rights. You got to tell people you want to utilize these rights. Or if you have an AIA or consensus docs subcontract, you got to know that your life just got a little bit less predictable, because subcontractors who walk in your door saying, hey, I'm looking to exercise some of these rights. I need more time, or I just need out of the contract entirely. That can put a damper on your day as a general contractor. But you need to understand that if it's an AIA or consensus doc document, their rights may carry water. Now, if you have a subcontractor with not one of these contracts, maybe a custom drafted contract or oral contracts, they exist. They happen all the time. They happen every day in Texas. Obviously, the situation is pretty reversed, isn't it? It's you've gone from knowing that there's force majeure language to now thinking in your own head, yeah, he might be arguing what we talked about at the beginning, which is contractual impossibility, impracticability, frustration of purpose. But what do you know? You know, yes, those defenses exist. No, they're not very good. They might get a little bit better under post-COVID era courts. I actually do expect them to get a little bit stronger. I actually expect a case to declare eventually, either at the district court level or Supreme Court level, that COVID is going to be listed as one of those impossibility or impracticability uses. I see that coming down the road if the parties litigate in that direction. All right, last topic I'm going to cover extremely briefly. I'm going to throw it up here for everybody to see. Repudiation, anticipatory breach. Okay, this is how you get in trouble on the phone. This is how your subcontractors get in trouble with you on the phone. This is how you, as a general contractor, get in trouble with your owners on the phone. So be careful what you say matters. What is repudiation? It is an that's supposed to say an absolute and unconditional refusal to perform without just excuse. Okay. This comes in two ways. It comes in the, hey man, COVID, I can't do it. I cannot do it. Okay. You've just told me absolute and unconditional refusal to perform. Oh, but without just excuse. Well, is COVID a just excuse? That depends on the facts of the certain scenario. How did COVID interact with that company's ability to perform? Because under this repudiation scheme, that's in fact what's going to have to be proved at trial is, did it or were you able, would you have actually been able to do it regardless? You just maybe didn't want to, or it was commercially a worse situation for you to finish the project, something like that. And the jury's going to decide whether, whether and to what extent COVID really stopped you from performing. So whatever you do, don't get on the phone and just say, COVID, stay-at-home orders, lots of stuff shutting down, man, I ain't doing it. Don't do it. And if you get a phone call that says that, they may very well have breached their contract with you. That opens up, you're going to need to talk to a lawyer about that, but that opens up a whole new can of worms from that point forward, and actually gives you as the general contractor or a subcontractor further legal options. Demanding new terms can back. Oh, same thing. My final point is demanding new terms. Okay, so that there is case law on the books that demanding new terms, called a hold-up game, just right in the middle of a contract saying, hey, I gotta have this, or it ain't happening. Okay, demanding new terms can be a breach of your contract. This is not like asking for a change order. Okay, that's a different situation. That's asking. Demanding that I need this or I'm off the job, that is potentially a breach of contract. It's a breach of contract if it's happening to you and if you make that move. So be very careful in these COVID situations because I don't want anybody giving up their right to recover for their work or their honest to God legal or contractual rights to get either more time or to escape the construction altogether and get paid for what you've already built already. That is all I have in this presentation. Again, my name is Ben House. I'm a founding partner at House, Perone & House in Houston, Texas. Seth, if I'm available to answer some questions.
Yeah, Ben, that was a great presentation, and I know a lot of good information for contractors and anyone that's in the industry. I'm going to open it up. We have a lot of participants, and we've had a number of questions about getting copies of these slides. So we're going to go ahead and make
Excellent.
that available
Good.
to everyone. And I've told them that they can ask you questions on the Expert Center, but I think we have a bunch of shy people today. So unless in the next 30 seconds or so someone's going to ask a question, then we'll wind down. And I guess everyone stay safe and healthy out there. And we're from Levelset, Expert Center, post questions, get lawyers to answer, point you in the right direction at absolutely no cost. You get to speak to people like Ben, who are really authorities and thought leaders in their fields, especially within their states. And I know Ben mentioned to me earlier, but not, even though they're based and certainly work all over Houston, they do work statewide in Texas. We try and we do a good job at making sure that the construction lawyers in the Expert Center actually have a lot of experience practicing construction law.
That's
So
what I'd say.
Ben, anything else? Or I don't see any questions right now. Wait. I do see a question. Okay. Well, I don't know if you can answer this, but how much of this is to translate to California? I guess we have a California person slipped in here. I don't know if you want to get into that because
No, my answer, I can answer it. My answer is I have no idea.
yeah,
I can actually do a little bit better than that.
okay.
Force majeure is not a Texas specific thing. How the force majeure terms are interpreted, that is state specific. Some states say if it's not the exact dang word in that term, then you don't get any more time on your project from force majeure. Other states are much more liberal with it and say, oh, you got a force majeure clause. They're all about things being unforeseeable. And because of that, if the unforeseeable thing was unforeseeable, we're going to let you slide a little bit on that. We're going to interpret this to cover that and give you the more time you want, or maybe even terminate the contract. But yeah, specifically to California, I can't speak to that. I'm sorry.
And we got another question coming in. What can you do if payment is not received even after sending lien notices? Can you threaten to stop work unless payment is received?
Okay, that depends on your contract. So non-payment is usually a breach of contract. And what a breach of contract means is, and I don't want to get heavy in legal jargon here, but what a breach of contract means is your duties under a contract are forgiven. Your performance is forgiven. What does that mean? That means if you don't pay me, I can stop showing up. I don't have to do anything else. Now, and that's good leverage. That can be good leverage, just not showing up because you weren't paid. It always, in subsequent lawsuits, it always turns into a fight between, well, he didn't show up, well, he didn't pay me, well, he didn't show up, well, I didn't pay. It gets very factually dense. But the critical thing is protect your lien rights. Protect your lien rights, protect your lien rights, protect your lien rights. And the next most critical thing is read your contract, because some contracts have, if you have some type of, if this is a result of a payment dispute where you're asked to do more work, but you haven't agreed on a price. Okay, some contracts have specific language that says the general contractor can order you to do the work, and we'll just agree on the price later. And if you don't do that, if you don't stay on the site and do the work, you've breached your contract. So that's the only, well, that's not the only situation, but that's one of the major situations where I would warn against walking off the job. But generally speaking, if you haven't been paid, that is a fundamental breach of the contract.
Ben, we'll have a follow-up to that, and then we'll wind it down here. Chris asked, but does the granting of additional time particularly translate to additional money for the time?
No. In fact, in my experience, it's technically been the opposite. It's typically, not technically. There is such a thing as a no damage for delay clause. It is a very common clause. I don't quote me on this, but I think it's in both AIA and consensus docs. But basically, it means that if the owner causes delay or the general contractor needs to delay for some reason, and they send proper notice that they are delaying, you don't have to demobilize, but you just gotta sit there for a little while, and you just kind of gotta eat it, unfortunately. A lot of contracts are drafted like that. Now, there are terms, there are terms in the more sophisticated, like AIA and consensus docs contracts, that speak in greater detail to the type and reason for the delay. And under certain circumstances, read your contract, number one, there is remuneration available. There is money available for those delays. But in most circumstances I've seen, it's pretty rare.
Well, Ben, thanks again. And to all our participants today, I think we look forward to more webinars with Ben in the future. Maybe we can get him to post a blog. I know he's already answering a lot of questions out there. So again, Ben House, located in the Houston area and servicing all of the Texas area for construction law. Everyone have a great day, stay safe, and look forward to talking to you soon. Bye-bye.
Thank you, everybody.
Thanks, Ben.